Good morning. My name is Jonathan Goldsmith, Senior Project Counsel at the European Lawyers Foundation. I will be your moderator this morning. Welcome to the webinar organized by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe in collaboration with the Unified Patent Court on the Unified Patent Court 1 year on. This webinar is organized in the framework of an EU project called TRAVAR, the Training of Lawyers in Various Areas of EU Law, and it's co-funded by the EU. I have a number of announcements to make whilst people are entering the webinar. This webinar will be in English. Interpretation is provided in French and Spanish, and you can find the language channels at the bottom of your screen. Please use the question and answer box to put questions to the speakers. We prefer you to put the questions in English if possible, and we strongly encourage questions. Questions will be answered at the end of the webinar when we have a specific time set aside for questions and answers. Please don't use the chat for questions. The chat can be used, as people always do, to introduce yourselves and say where you're from, but please put the questions in the special question and answer box at the bottom of the screen. This webinar is being recorded, and the recording will be available on the European Lawyers Foundation website and also on the YouTube channel at EU Lawyers Foundation. You're invited to subscribe for free access to past and future webinars. And now come two issues about which we get a lot of questions, so please take note. All the presentations which will be made today will be uploaded onto the European Lawyers Foundation's website. People often ask questions, will we get the presentations? Yes, you will get the presentations. They will be on the website, and so please consult them on the website later. Question number two is, we do not provide continuing legal education, certificates. What happens is your bar will provide you with a continuing legal education certificate. We provide the bars with the connection time of those people who have participated in the participants list. And then you approach the bars and the bars approach us and we tell them that you have attended. So as I say, we don't provide the certificates, your bar will, and we will give them the information. Now we begin the webinar, and it's my great pleasure first to introduce Pierre-Dominique Schupp, who is the president of the Council of Bars and Law Societies of Europe, the CCBE, who will make some introductory remarks. Pierre-Dominique became president of the CCBE at the start of this year, and before that he was president of the Swiss Bar Association from 2013 to 2015. Pierre-Dominique, over to you.
Thank you, Jonathan. Dear all, as president of the CCBE, I'm really and very much delighted to welcome you to today's webinar on the Unified Patent Court 1 year on. I'd like to thank the CCBE and our colleagues from the European Lawyers Foundation, in particular Jonathan Goldsmith and Alonso Hernandez, for their efforts in putting together today's important webinar. I also would like to thank all the distinguished guests and speakers today. Alexander Ramsey, Registrar at the Unified Patent Court, Ryan Keldon, Presiding Judge of the second panel of the Court of Appeal and member of the Presidium, Peter Block, Legally Qualified Judge at the Court of Appeals, our two practitioners from the CCB Working Group on Patents, Jochen Brühling, Partner at Krieger Mees Graf de Gröbel in Düsseldorf, et Emmanuel Larère, partner Gilles Laurette Luel in Paris. And of course, all participants that are present today. Thank you for joining us. We are today around 400, which is really a great success. The CCB established a working group on the Unified Patent Court as far as back as 2007, where there were early discussions on the creation of that court. Over many years, the CCBE working group prepared several position papers on various issues, including representation before the Unified Patent Court, comments on the draft of procedure at that time, the issue of a European patent litigation certificate, and the issue of the code of conduct, just to name but a few issues. We are now in 2024, and the Unified Patent Court has been operational for just over a year. It's really a good time to make a first assessment. I am therefore delighted to welcome you today on this important and timely occasion and wish you a wonderful day and wonderful discussions. Thank you very much.
Thank you very much, Pierre-Dominique. Thank you very much indeed. And we now move to the first substantive session of the day, which is a general introduction to the Unified Patent Court. And I'd like to welcome our speaker, Jochen Buhling. Jochen is a partner, as Pierre-Dominique said, at the IP law firm Krieger Mess in Dusseldorf, specializing in patent and trademark matters with a strong focus on IP litigation. He advises national and international companies of all sizes and has distinct experience in pharmaceutical and biotechnological inventions, chemistry, medical engineering, and electronics. He's an honorary professor at the University of Münster, where he teaches IP law classes. He was Reporter General of the International Association for the Protection of Intellectual Property and president of the German group of that association, AIPPI, from 2014 to 2020. He's vice president of the German Association for the Protection of Intellectual Property and Copyright, and a member of its patent committee, and chair of the Intellectual Property Committee of the German Bar Association. Jochen, over to you.
Well, thank you very much, Jonathan, and thank you very much also to the organizers for inviting me to be part of this seminar today. It is a great pleasure and also an honor to be able to talk to you about a little bit about the Unified Patent Court and some of the issues. Good morning to everybody, and I hope we will have an interesting session, and especially if there are any questions, as already said, the Q&A box and the Q&A session part at the very end will hopefully clarify that. Well, I should start with a very warm happy birthday and happy anniversary to the Unified Patent Court and to the UPC system as a whole. I was asked to give you a short introduction, and I decided that rather than giving you the technical explanation of how the court works and what it is, I think you can all find that on the website of the court. I would like to share some more general thoughts with you, and actually I need to share my screen. I hope this is working. Is it working?
It is.
Okay, indeed, very well. I would like to, let me just see how that works. There we go. The slide moved, didn't it, Jonathan?
Yes, it did.
Yes,
Yes,
it did.
it did.
Okay, perfect. Thank you. Well, what is the Unified Patent Court and why is it there? If we look at this quote from Thierry Breton, Commissioner for the Internal Market, patents are essential for European innovation and competitiveness. The new unitary patent system provides a one-stop shop for the registration of patents in Europe, making patent protection stronger, simpler, and less expensive. And currently we have 17 member states, and he's encouraging the remaining member states to join the unitary patent soon, and I'm sure we'll hear more about it from Alexander Ramsey in a minute. Well, the unitary patent as a patent and the unitary patent system and the Unified Patent Court is something which people have envisaged for a long time, and they have actually desired this for a long time, especially the European patent with a unitary effect, which is then the unitary patent. It's a project that has been going on for more than 4 decades now, and finally it has come to a good end, I would say, already after this first year. In the past, there was a lot of skepticism in many countries, including Germany, and frankly, myself, having been involved in many of those discussions and debates, I very often come to a point where I thought, well, maybe this is not the right way to go. And without going into the details of the history, there have been many different attempts and many different approaches. And finally, we have come to a solution, I think, which is an excellent piece of work, and including everything that it encompasses, and that is quite that has been a quite an achievement. And now we see lots of optimism and euphoria, I would call it. It's not only about the European Soccer Championship, which is going on right now, but this is a really different European project that has come to life, and which is now very vivid indeed. So part of this whole system of the unitary patent and of the unitary patent system is the Unified Patent Court, the UPC, which we are going to talk about today. And that is certainly necessary for the enforcement of patents. We all know that patent protection is only as good as the means for enforcement are. If you have a patent or a utility model or any other IP right, whether it's trademark or design, and you're getting trouble enforcing your rights and putting it into practice, then it's only half the worth of all the efforts and all the means that you're putting in. So necessary for enforcement on the one side, but also the court serves as some corrective means and as a corrective institution for everything that is happening, and that includes the granting of the patents, the enforcement of the patents, and so forth. And we will see how that works. The unitary patent system, as it came into play, goes back to 2012. It encompasses various instruments, I should call it. First of all, it's the Unified Patent Court, and that is based on the agreement of the Unified Patent Court together with statutes and everything. It's a multinational agreement which was concluded back in 2012. We have 2 regulations of the EU. One is the creation of the Unitary Patent Protection, that's Regulation 1257, and the other one is a translation regime regulation on applicable translation agreements, 1260. Both of them are also from 2012, and you might wonder why it took so long to come into play. So now we're in 2024, and we're celebrating the first anniversary. And so the starting point was the 1st of June 2023. So it took about 11 years to come into play. Well, there was a lot of it. As you know, international agreements are not self-executing. They need to be transformed into national laws, into national instruments. The member states need to be part of it. Germany played a big role in the delay, I should say, since there were at least two actions being brought before our German Constitutional Court, because the applicants thought that the whole system should be against the German Constitution, part of it being that you are transferring autonomous rights from Germany to a truly international body which is separate from anything else. Finally, everything was resolved, not dissolved, and we could come to a start. So what is the UPC? I'm trying to tell you what the UPC is and what it is not in this introductory part. First of all, it's an absolutely unique court and a court system in that it covers a number of countries. It is a truly international body which has jurisdiction over international matters. It is not linked to the European Union. It is not linked to the member states. It is absolutely unique, and I don't think you find any of that worldwide in any field of law. So it is truly something that was established for the first time after a long period of thinking and a lot of efforts that went into it. So we have a multinational, international European court, which is common to the participating member states. And the word participating is important because, as you probably know, this project, the UPC, currently does not cover the entire European Union. It was a project and a product of the enhanced cooperation of some of the member states. Actually, some is almost all of them. We have 25 participating member states out of the 27, and 24, 25, depending on how you count it. We are currently at 17 who have ratified and deposited their ratification document. So that's why the participating member states are important. It has a completely independent setup, procedural rules, and panels of judges. First, international. First, to mention that we have not only a panel of one nation, but we have minimum 2 different nations on a panel. That makes it multinational, international from the outset. The second important thing, we have legally and technically qualified judges on the panel. Not in every case, in every situation, but it is possible, at least for every panel, to be equipped also with a technically qualified judge, something which is not known to the ordinary civil courts. For example, in Germany, where I come from, we have mixed panels at the Federal Patent Court, but not in the infringement courts, in the civil courts where we're dealing with. Important thing, all these judges and all the member states have very different legal and cultural backgrounds and traditions, and I think that is reflected also in the product that came out of it. When the project started, the UK was still a vital part of it, and as you all know, the Brexit changed the world and the landscape tremendously, and also with regard to the UPC. There has been a lot of influence from the outset from the UK and from common law views, and now there is not much left with regard to common law when you look at the participating member states, but we still have some of the ideas maybe in the rules of procedure in the UPCA, and so it shall be interesting to see what comes out of it. Seeing that my time is running, I would like to go to this slide. What the UPC is not, and what one should not expect from it. It's not a branch of the EPO or of any other EU institution. I mentioned already that it is entirely independent. It is not a copycat of the community trademark courts or the community design courts, which you may be familiar with, simply because those are still national courts where the judges take off the national hat and put on the community trademark or community design hat and apply different laws. But in principle, the way the court works is still as it would work under its national regime. And it is not a continuation or a supplement of national courts. It is something completely different and should not be mixed up or confused with national courts. But at the same time, as I said, we have judges from different backgrounds, and that'll be the interesting thing to see in the future. Will there be convergence of different views, or not, and how is this going to play? I think it is a wonderful experience for all of us, but also for the judges to be sitting on panels like that. We will hear more about it, I'm sure, from the judges in a minute. And whether or not this whole system will be successful is actually in our own hands. And I'm talking about judges, practitioners, and also the parties. Of course, the parties are the ones who are again in the hands of the judges and of the practitioners. But I think we have seen in the first year, we've seen a very good start, and we can shape it now. And I think it is a rare and a unique chance to see something like that come to life and to be able to work constructively on this. And Jonathan, I see you. And so with that, I would like to finish my introductory remark. Thank you very much.
Thank you very much indeed, Jochen. Thank you. Yes, I shall keep a strict time limit. That's very good. Thank you very much for your introduction to the court. We move on now to our next session, and we are very honoured to have the registrar of the court. This will be views from the registrar. The speaker is Alexander Ramsey. Alexander was appointed the first registrar of the UPC in January 2023. Before that, he was at the Swedish Ministry of Justice until 2016, and both served on committees of the UPC and served as a judge on the Swedish Patent and Market Court until his appointment as UPC registrar. He was involved in the negotiations on the enhancement of the European patent system between 2008 and 2013 in his role as Deputy Director at the Swedish Ministry of Justice, and then he was elected Vice Chair of the Preparatory Committee of the UPC, and then Chairman of the committee, which he held until February 22, when he was the first Chair of the Administrative Committee of the UPC, and now, as I say, since January last year, he's the Registrar. Alexander, over to you.
Well, thank you, Jonathan, for the nice introduction. Hopefully you hear me well.
We do.
Listening to the first intervention, it almost got me a bit nostalgic. As you hear, I've been involved in the dossier for a long time, since 2008, and then it has sure been a bumpy ride during all those years. Of course, having that history, I couldn't avoid putting my money where my mouth was, and of course needed to join the system once I got the opportunity to also work in the court as the registrar. I'm really happy to be here today. I am enjoying the list of participants. We're close to 200, I can see, so a very good uptake. I can congratulate the organizers for that. So really nice to be here. I hope to be able to give you some impressions from the registry, a little bit of statistics, some words on the CMS, obviously. I know you wouldn't expect nothing else, and a little bit about what we're dealing with at the registry, also in other matters, to give you a bit of an insight. Hopefully I will not ramble on for the full 30 minutes. I think I have until 10:50, if I'm not mistaken.
Yeah.
I would be delighted if you would ask questions, because it becomes so much more interesting if you do. If you don't, I heard that there will be a Q&A afterwards, and then we can of course deal with them then. But don't hesitate. I will not be offended if you interrupt me. I won't be able to see you, I guess, because I will be sharing. So, but I'm trusting that Jonathan will help keeping track of the hands out there if someone would have something for me. As I said, I would be delighted if that would be the case. I will now try to share my screen. Let's see if I can manage, and you can see. Hopefully you see a white screen now. Do you?
Yeah, it's there.
Do you see the full screen, Jonathan?
Full screen.
Oh, great.
Alexander.
We had some technical difficulties before, but I seem to have been able to sort it in the meantime. Okay, good. Then hopefully you can see the screen moving as well.
Yes.
Great. then I'm confident in the techniques. Okay, here you see a nice picture of our division in France. It's even nicer if you look from the division to on the other side, because then you see the Ile de Cité, really in the middle of everything there in Paris. So it's a great spot. These are I had a look at the CMS Friday or Thursday, I mean. So these figures are from June 20. You probably know that we try to publish from the registry side at the end of each month. We publish a bit of statistics that we kind of think could be interesting for the users. So these are I mean, the same categories of figures, but then to some extent updated. So as you can see from this slide, since the start of the court, I mean, this is during 1 year, we have attracted 153 infringement actions, which is an interesting number, because if you look at the statistics from end of May, you can see that back then, if I recall correctly, it was 138, because if I am not mistaken, because I think it has been 15 more cases just during the 3 weeks in June. So I would say quite a good uptake on that. So the court is attracting more cases than what we believed it should when we negotiated this and when we prepared in the preparatory committee. So that's a good start. We also have 180 counterclaims for revocation. However, which we also point out in our monthly statistics, this is an inflated number, because you must then need to take into account that our case management system weren't able to cope with joint counterclaims, so it forced people to file individual counterclaims concerning the same infringement action. That has been fixed, so it's not that is not the case currently, but it still affects the numbers to some extent. I think they are kind of relating to about 70 infringement cases, I think, these counterclaim for revocations. I don't have the exact number today. 40 revocations actions at the different central divisions, the 2 sections in Paris and Munich. I think there are 4 in Munich and 36 in Paris. A number of provisional measures, orders for preserving evidence and inspection, and we have 1 claim for damages that is actually handled outside the case management system, because it simply couldn't handle that one. And we also have a couple of declaration on non-infringement. So if you look on the bottom line number, 412 cases, but of course then it's not reasonable to count all the counterclaims for revocation actions. But I think the number of the infringement actions it speaks quite a lot for itself. So we have had a good uptake if you look on the caseload at the court of first instance. Here is the schedule that we usually publish every month, where you can follow the different actions on the different divisions. What I would like to well, you can of course point out different issues here, but I think the main issue I would like to point out is that also Lisbon has got the case now. It has got a provisional measure case. I think it came in mid-June. So it's now only the division of Ljubljana that are waiting for its first case. So if any one of you out there are considering filing, why don't try Ljubljana? So then we'll get cases all around. Another point is of course the strong presence of cases in Munich. You can see we have 60 infringement actions if you look on the CMS right now. The other German divisions are quite busy. You can see Düsseldorf, Mannheim, quite a lot of cases, and then the other divisions come. You have Hamburg and the Nordic Baltic division, and etc. etc. So, but 1 year after the entry into force, all the divisions except Ljubljana are having cases, which I think is good. Moving on a bit on languages, what is the conclusions from this side? Well, if you have followed our statistics, you have seen that we started off with German being bigger than English, and now English has overtaken German when it comes to languages of proceedings. And it's increasing, I would say. We have a few cases in Dutch, Italian, and French, as you see, but the system is mainly running on German and English as it stands now. This is, of course, not something that the court influences that much. It's up to the parties to decide what kind of language you decide to file in. And I don't know. It might be that Peter or Rian will touch upon this, how this is being dealt with by the court. I know, for instance, that even at the Court of Appeal, for instance, even if the language of proceedings at the Court of First Instance has been German, there have been cases where the parties and the court together have agreed to run the case at the hearing in the Court of Appeal in English to make it simpler and to avoid the need of translation and interpretation. So the language issue is interesting. It's not so much for the court to decide, but we are following the development, and it's up to the parties basically to use the language regime of the court as it sees fit. But this is, of course, also something. Listening to the first intervention about the history of the dossier, the language regime of the court is, of course, something that has been heavily debated in the past. Would it be too complicated to work? I think one conclusion 1 year ahead, 1 year into the system, no, it's not too complicated. I think both the parties and the court has a way of managing to find a workable solution that is practical. So I think that, and that's also kind of looking back, my own position back in the days on this was that I was quite certain that this would be the case. So I was not particularly worried, but I know this was frequently raised in the debate before the entry into force. Technologies, I always forget what's what in the patent clauses, so I've listed them on the left side of the screen. You can see that the trend, what's being litigated in the Court of First Instance. See, for instance, that we have a lot of electricity cases being dealt with in infringement actions. Can see class H is quite high on the graphs. You can, of course, study this as you will. I will not go into it that much currently. The cases of the Court of Appeal, it's also the caseload of the Court of Appeal. It's also growing, as you can see from the slide. For instance, we have 48 procedural appeals last week, if I was correctly informed. And quite a few other applications, which I know that you will hear more of from Rian and Peter. So I will not, of course, go into this in detail. But it's clear that the caseload is also on the rise at the Court of Appeal, even though we haven't had the first final decisions, final judgments from the Court of First Instance. So we are still waiting for the bulk, so to say, of the appeals to hit the court in Luxembourg. And yes, the nice picture on the slide, it's our slightly Star Wars inspired building in Luxembourg, built originally for the European Parliament in the 70s, and we have worked our way up in the building. We started at the very lowest floor, and now we occupy not only that but also the very highest floor. So the staff is growing. We are becoming bigger, which means also that we have grown in the building, and it's we are co-located in this building together with a couple of other courts, among others the EFTA courts and the Benelux court. So it's currently some kind of a court building in Luxembourg. Okay, now for keeping track of time, the case management system, IT development. We have a case management system of the court. The court is supposed to be a digital court. It's actually set up in the agreement and the rules that we shall be. So we shall be able to we shall make good use of all the digital means out there. So already in the preparatory phase, a case management system started to be developed. So it was developed before the court came into practice and before we had the judges, which is an additional, of course, challenge also in view of IT systems in general. That I mean, generally can be a challenge having a new IT system, and indeed this is a new IT system, so it's clear that we have a different layers of difficulties with it. One is the perhaps the ordinary level of difficulty, meaning that it's a new system, so it's prone to have bugs. It happens also in our system. We also have the fact that it's not fully yet implemented in all different processes, so we still discover things that is simply not possible to handle in the system, which of course provide a challenge and a difficulty that for both parties and the court to overcome, to find workarounds. And it's also a bit complex, so it has been developed in a way where the rules of procedure has been kind of, how should I put it? There are different workflows for all the different rules. So it's very specific on everything, which means that it's quite complex, which means in turn that, well, it doesn't necessarily mean that, but in our case it does, that it's also very difficult to change lanes once you have entered into one process. It's difficult to go back, and it's difficult to change into something else. If you have, for instance, started something in the wrong lane, it's difficult to change afterwards. So that's another layer of complicity when it comes to the CMS, which we are kind of struggling with. So we are spending quite a lot of effort at the court to develop the CMS, to handle the different problems that occur in production, to develop the bits and pieces that still are not there, and also to find ways to make it more flexible and easy to use. And we're doing that, of course, in cooperation with our external provider, in cooperation, of course, that goes without saying, with our internal users, the judges and the clerks who were not there when the system was built, and also with external users. So we are working together to some extent also with the observer organizations of the Unified Patent Court, those who have observer status in the admin committee. So we're keen to get the views and feedback from users, and we have organized a set kind of regular meetings with those organizations to provide us with the feedback. So that's, for those of you who don't know, it's EPLO, EPI, EPLIT, and Business Europe. So we're trying to work transparent in this way, and to provide information about what we're doing, how we're doing it, and also get feedback from users, what they would like to see, what kind of developments and improvements they would like to see. I'm not sure if I have a slide on that. Yes, I have. We are devoting quite a lot of our internal resources to finding solutions for the practical problems that occur on the case. I have promised to file to give you some advice to practitioners, and the general advice when it comes to the CMS is to be patient. We know that it has got its flaws. We know that it's not perfect. We're working quite hard to provide something that will be better. We are working quite hard to improve it, and during the first year we have been focusing to quite some extent to make the cases move, to find solutions in production, to find workarounds when people get stuck. And if you find yourself in such a position, I would recommend you to use the contact formula on the website at the bottom. If you use that, you will enter into our so-called ticketing system, which would mean that your request would enter into the realm of the service desk, which then will forward it to the different relevant teams within our organizations. And if it's an urgent request, we will give it our full attention and try to solve it as quickly as possible. So The general advice on the CMS is to be patient and use a contact form and the ticket system, and we will. You have my word that the staff of the court will try to find solutions to anything that means that you are stuck in a case, and we will also make improvements to the general system. We do have a website. We are working to improve how things are being displayed. It's constant work in progress. Currently, we have some focus on how we are displaying the orders and decisions, and how we are displaying the calendar functions. There you will see in the coming months, you will see improvements and a more modern display, I would say. I know that I am perhaps supposed to end now. I don't know if I have some more minutes. Do I?
You do, Alexander. Carry
Okay.
on. Yeah.
Okay. You just interrupting Jonathan if I become too tedious, or if you want me to stop. Okay.
No chance of that. Fine.
Okay, good. Human resource judges, I cannot resist having this nice picture on my slides. It's from the oath taking in Paris 1 year ago. All the first instance judges lined up in their beautiful robes in a beautiful room. A great occasion. Unfortunately, I was not able to be there myself, but it's a nice picture. The human resource issues, a few words on that. It's really more for Rian, by the way. Sorry, Rian, but because yes, Rian is in the Presidium, and so am I, of course, but I'm a non-voting member. The Presidium is the executive committee of the judges, and the Presidium is key because the Presidium is making a lot of decisions for the court. Among others, the Presidium is making the decisions on the working time of the existing judges. As you know, we have different percentages all around Europe on the judges. If you look on the legally qualified, they range from 20% to 100%. The technically qualified judges, they work, some of them work on a percentage, but the vast majority of them work on a case-by-case basis. So when it comes to these percentage judges, I mean, that's constant work in progress, evaluating the caseload, evaluating the need of work time, and making sure that you have the budget for it. And it's a decision anyway by the Presidium to decide to increase a judge, to alter the outtake of work time. And I know that there are a lot of time and energy and effort goes into that, and quite a few judges have been increased in their working time during this first year to cater for the growth of the case balance. As you can see, when it comes to new judges, which also might need to appoint, then it's a decision of the administrative committee who decides to appoint any new judges. And as you probably are aware, we have recently appointed new judges in Munich and Mannheim, and of course also for the new central division section in Milan. When you have new judges, you of course need to make sure to onboard and train them. For instance, now we are running a webinar program for our recently employed legally and technically qualified judges, which I think it's a 5-step training in different matters that concerns the court, everything from the rules of procedure to the HR system and the IT support tools of the court. So it's of course also a bit of a challenge for an organization like ours that is spread from Helsinki in the north to Lisbon in the south. But we are trying to do our best with digital means, and then of course also organize physical trainings now and then. We have one coming in September where we will meet everyone, legally qualified, technically qualified, and clerks will meet in Vienna. So I think we will probably be around 170, 180 people all in all during that training. So really looking forward to that, meet everyone in person. Human resource staff. I think staff is key. I'm the registrar, so I'm responsible for the administrative support of the court. So I like my staff. I try to take care of them as good as I can together with my deputy, Mr. Axel Jacobi, who sits in Paris, who has got a special responsibility over the sub-registries out in the different local and regional divisions. We have over 50 clerks at the moment. We also in the different locations, and then you need to also remember that we have between somewhere 25, 30 other administrative staff, mainly located in Luxembourg, where we have our administrative center, where we have our IT team, where we have HR, finance, the secretariat of the court, the communication department, our translators, and the different assistants to myself and the president. So, and all that staff, the clerks and the admin support staff, the other admin support staff, they are provided which you might know by the member states during an initial period of 7 years. And that's of course that has got, I mean, there are different backgrounds to that decision, but it's of course has got its benefit. We don't need to deal with, some parts of the administration of the employments of that staff. On the other hand, it means that you really need to have an agile cooperation with the member states to be able to make sure that you have the correct staff on the different locations. Users might see that, okay, now this division is very burdened. Oh, come on, you need to appoint more judges. I see that, okay, this division is really burdened. I really need to get more staff, because if you don't have the proper number of clerk, the cases will not run. So, and in order to do that, you really need to liaise very closely with the member states to make sure that you are properly staffed. And also all that staff, again, the same as for the judges, they need to be onboarded. You need to provide them with training so that they feel that they are competent, that they know the different tools. For instance, we have a complicated CMS. The clerks are working a lot with that. So it's of course it would have been much easier if everyone were in one place, but now they're also spread. So we need to make sure that we use digital tools as much as possible to be able to cooperate. So I think that's it for me. Thank you for your attention. If there are any questions, I would be happy to try to respond now or later. I will now stop sharing so that I can see your expressions. See if I can get rid of the
There are no
screen.
questions, though I would encourage questions, but maybe I can ask a quick one. We have 3-4 minutes left, which is, you were heavily involved in the preparation for the UPC, as we saw from your CV. You know, all the best laid plans of mice and men go awry. So looking back, what is the single most unexpected thing which has happened despite all your preparations?
The single most unexpected thing. Well, that's kind of a difficult question, Jonathan, because I think that, I mean, generally speaking, I think a lot of the things went as expected. I mean, my greatest concern as the registrar is our case management system. And of course, I would have liked the case management system to behave a little bit better than it does. But on the other hand, it's a new IT system. So I think that if you look on it soberly, I to expect that it would go without any difficulties would have been a bit naive. So, but I mean, that is otherwise, I think the languages, as I said, I think it works rather smoothly. People being spread all over Europe, we knew that would be a challenge. I think it works admirably. We have a great team. They're really pioneers. They have a very good spirit. So I think that works also quite well. We have more cases than we expected. I always say that before we started that it will be. I've always been very confident. I've always been one of those going around to conferences saying that this will be a success. I always say that as long as we manage to attract the best possible judges of Europe, then there is nothing that can stop the UPC. And I think that has actually proven to be true, because we have attracted extremely qualified judges who are very dedicated, who work very hard for the UPC to become a success. And I think that is also what lies behind our good figures on the caseload. So there's really nothing that kind of came as a big surprise to me that this didn't work out as planned. But perhaps it came as a surprise to some of those naysayers who were quite negative that it actually worked, and no one has challenged the authority of the court in the way that some people thought they would. So sorry, I don't have anything else.
No, that's a good answer. That all the preparations went as expected, and you planned for everything. That's excellent. That's excellent.
Well, we had some time. We had some time, Jonathan, due to the different delays.
Indeed. Thank you very much indeed, Alexander, for your extremely interesting presentation on the court, and we're perfectly on time and should move on now to our next session, which is to do with the Court of Appeal and its case law. And we're very honored to have with us two judges. First of all, Rian Kalden, who is presiding judge of the second panel at the UPC. And she's been a legally qualified judge as from June 2023. And as Alexander says, she's a member of the Presidium of the UPC as well. She started her career at the Amsterdam Bar with the law firm Stibbe, and she started in the intellectual property department and then went to company law on mergers and acquisitions. And after that, she was appointed judge at the District Court of The Hague, where she joined the Patent Chamber and became vice president of the Intellectual Property Division of the District Court of The Hague, and then appointed a judge at the Court of Appeal of The Hague and headed the division that covers all IP cases for 5 years. So with her, and they'll be giving a joint presentation, so I present them both at the outset, is Peter Block. And he's now a professor at the Center of Intellectual Property Law of Utrecht University. He holds the patent law chair. He started as an attorney at law in Rotterdam and Amsterdam, but he's now a deputy judge at the Commercial Law Chamber of the Court of Appeal in The Hague. He specialized in intellectual property law and in particular patent law. From 2015 until last year, he was a judge at the Court of Appeal of The Hague. And before that, he was a judge in the Intellectual Property Chamber of the District Court of The Hague. So I thank you both Rian and Peter, and I hand over to you for your joint presentation on the Court of Appeal. Thank you.
Well, Jonathan, thank you very much for this kind introduction. I hope you can hear me.
Yes, we can.
Okay.
We can. And we can see your slides as well.
Okay,
yeah.
Good. Thank you very much. Well, I said thank you very much for the introduction, and it is a great pleasure and honor to be invited to this conference and to present to you our first decisions and experiences. It will be the decisions of the Court of Appeal, and then you may think this is going to be a very short presentation because, well, it's a new court and it takes some time until the cases arrive at the appeal level. But you've seen the numbers presented by Alexander Ramsey, and we have been actually quite busy, so there's a lot to present. Next slide, please. As you can see, we had to be selective actually, and still, if you are selective, there is quite a lot to discuss. I will start with the first three, and then I'll give the floor to Rian Kalden to present the other ones. I start with the first one, which is a first in many respects. It is one of the first cases that was submitted on the 1st of June, so on the first day of the court, and it was a PI, so a preliminary injunction case, and it was also one of the first cases heard by the Court of First Instance, and where actually a injunction was granted by the Court of First Instance. Next slide, please. Next slide, please. As said, the Munich local division granted the request, so then it came in appeal, and it was the first PI case that the Court of Appeal had to decide on. And you can imagine that there are a lot of issues that had to be decided in this case, and I'll have selected two of them to present to you. And the first is the standard for granting a preliminary injunction, and in particular the level of certainty that is required. And that is quite an interesting issue, actually, because the national approaches, if you look at the national courts, quite diverge. There are jurisdictions like the UK where they have a rather low standard in this respect. There the standard is whether there is a serious case to be tried. And one of the British judges once explained to me that means that that standard is not met if you can't be serious to bring a case. So that is a rather low standard. On the other hand, there are jurisdictions in which there must be no reasonable doubt, for instance, on the validity of the patent, which is a rather high standard. And what the Court of First Instance here held was that the sufficient degree of certainty that the rules require for the UPC is somewhere in the middle. It must be more likely than not. And basically, the Court of Appeal agreed with that. Next slide, please. Because that standard, you shouldn't set it too high, given the fact that preliminary injunction proceedings are dealt with in summary proceedings, so there are limited opportunities for presenting facts and evidence. On the other hand, next slide, please, the standard cannot be too low, because then it would mean that there was a rather great risk that you grant preliminary injunctions that later on have to be revoked because there was no infringement or the patent was invalid. Whereas, of course, a preliminary injunction can have quite some impact on the business of the defendant. So the standard must be somewhere in between, and the Court of Appeal has formulated it thus that it must be at least more likely than not. That's basically there is an infringement, and at least more likely than not that the patent is not valid if the defendant raises an invalidity defense. So that's about the standard. Related issue is which party is to present which facts and on which party is the burden of proof. There, the Court of Appeal basically used the same allocation of the burden of proof as for the proceedings on the merits. And that means that it's for the applicants to present facts and evidence relating to the entitlement to initiate proceedings. So if, for instance, if the applicant claims to be the patent proprietor, there must be, and it is in dispute, then it's for the patentee to prove that, and also for the infringement. On the other hand, it's for the defendant in proceedings where there is a defendant to bring forward facts and evidence relating to the invalidity of the patent if that is argued that it is invalid. As said, this is something that is in line with the allocation of the burden of proof in proceedings on the merits. It's also for the defendant to bring forward facts and evidence relating to the invalidity of the patent. So the standard is at least more likely than not, and the burden of proof is similar to the proceedings on the merits. That's the first issue that was decided in this case. The second one is on claim constructions. Therefore, but it's in the same case. That's why it's a second number one. And of course, claim construction is central to every patent dispute, and that's why it's important. In this respect, there is much more harmonization between the national jurisdictions. But there is some divergence if you look on to the case law of the national courts on the one hand, and the case law of the boards of appeal of the EPO on the other hand. The starting point for the UPC Court of Appeal is, of course, Article 69 of the European Patent Convention and its protocol on the interpretation. And under these rules, it is, of course, the patent claim that is not only the starting point, but also the decisive basis for determining the scope of protection of a European patent. That is, I suppose, for most of the people in the audience a familiar starting point. The question then is, how should this be interpreted? And there we have the interpretation protocol, and that is followed also by the Court of Appeal. And that says that on the one hand, the interpretation of a patent of a claim does not depend on its strict literal meaning. You should, as a court, always take the description and the drawings into account, not merely if there are ambiguities in the patent claim. On the other hand, next slide, please. The claim is not merely a guideline, it is still the decisive basis for determining the scope of protection. Of course, patent claims must be interpreted from the perspective of the person skilled in the art, and the end, the main aim is to combine, on the one hand, an adequate protection for the patentee with sufficient legal certainty for third parties. This is all, you could say, in the protocol. So in that sense, maybe not that surprising. More interesting maybe that the Court of Appeal held that these same principle apply equally also in the context of the validity of a European patent. And the idea is that there must be symmetry to the interpretation of a patent claim in infringement, in an infringement action and in a revocation action, because basically it's all the same patent. So that's the decision on claim construction. It's and applied to the facts of the case. It makes clear that although a patent claim must always be interpreted in the light of the description, that doesn't mean that you can use anything that is in the description to introduce some limitation into the scope of protection. The issue here was a patent relating to compositions and methods for analyte detection. And one of the points of debate was how the feature a plurality of analytes in a cell or tissue sample should be interpreted or construed, and more in particular, if a amplified single molecule is an analyte in a cell or tissue sample. And so what is a cell or tissue sample in the sense of the patent claim? Well, I will not go too deep into it, but the Court of Appeal held that the language of the claim makes clear that there is a distinction between, on the one hand, the analytes, and on the other hand, a cell or tissue sample, and that a cell of tissue sample implies that there is at least some structural basis for deciding establishing that there is still a cell or tissue sample, and that is not the case in an amplified single molecule. And the mere fact that in the description it is referred to also pre-processed cell or tissue samples does not mean that anything that has lost its the idea, the structure of a cell or tissue sample is still a cell or tissue sample in the sense of the patent claim. Okay, so that's about claim instruction, and I move to a completely different issue, which is the issue of parallel proceedings before, on the one hand, the UPC, and on the other hand, the EPO, and more in particular, revocation proceedings and opposition proceedings. The case relates to a revocation proceeding started by Bitzer. Next slide, please. And one day before the case started, the same party had initiated opposition proceedings before the EPO. And the patentee, so the patentee had to defend itself before two bodies, and it wanted to give priority to the EPO proceedings. So what it did was, on the one hand, it asked the EPO to accelerate its proceedings, and on the other hand, it asked for a stay of the revocation proceedings before the UPC. Next slide, please. The Court of First Instance rejected that request for a stay, and then the case went in to appeal. The relevant and applicable rule here can be found both in the Unified Patent Court Agreement and in the Rules of Procedure. The Article 32, paragraph 10 of the agreement says that the court may stay its proceedings when a rapid decision may be expected from the EPO, and a similar rule can be found in Rule 295, which you find on the next sheet, which also requires a rapid that the decision can be rapidly expected. But what does that mean? The patentee argued that these provisions must be interpreted and applied in the light of the fundamental right to have an effective legal remedy, and also on the basis of the principles underlying the UPC agreements, such as the principle for proportionality, flexibility, fairness, and equity. And in that respect, the Court of Appeal followed the patentee, because of the agreement must indeed be interpreted in that light. On the other hand, that does not mean that the stay must be granted in this case. Next slide, please. Because the rules also make clear that these principles must be interpreted in a way that will normally allow to have an oral hearing at first instance within 1 year. Now, and you can imagine that if you stay proceedings, that will be very difficult to have an oral hearing in 1 year. So, as a general principle, the court will not stay proceedings. Now, the mere fact that that opposition proceedings are pending before the EPO and that they relate to the same patent is not sufficient to allow an exception to that general principle. The member states, both of the EPC and the UPCA, have decided that there are two tracks in which you can claim a revocation of a patent, and that these tracks can be followed in parallel. There are jurisdictions where the legislator made a different choice, but this is the system that the member states have chosen. So the mere fact that both tracks are used is not enough for an exception. The patentee also referred to the principle of avoiding irreconcilable decisions, but that doesn't mean, according to the Court of Appeal that revocation proceeding must always be stayed. The first thing is that even if the UPC and the EPO reaches a different outcome on the validity of a patent, that doesn't mean that the decisions are irreconcilable. If the one body upholds the patent and the other revokes it, then there is a revocation of the patent. And what's more, there are other ways to harmonize the decisions. Of course, harmonization is important, and therefore you should organize things in such a way that the body that decides second can take the earlier decision into account. But where the UPC can be expected to decide first, there is no reason to stay the proceedings, to realize that aim. Also, the fact that the EPO has accelerated proceedings is not sufficient for an exception to the principle. There's a specific rule on the acceleration, and it refers back to that general rule of that I presented before, where the criterion is that there is a rapid decision. So, what does that in the end all mean? A rapid decision? Of course, you must interpret it in the light of all these principles set out before and the relevant circumstances of the case, which are on the one hand the stage of the opposition proceedings, and on the other hand the stage of the revocation proceedings. That about the concept of rapid, and on the other hand there's the may in both position, which means that the court has a discretionary power here, even if there is a rapid decision, and this requires a balance of the interest of the parties. Well, applied to the case, this means that no stay should be granted, so the Court of First Instance was right not to grant a stay here. At appeal, it was certain that the oral hearing in the revocation proceedings was already in June, whereas the oral proceedings before the EPO were in October. So on the basis of these facts, you can expect that there will be a UPC decision before the EPO decision, and moreover, the EPO is merely a first instance one. So if before you have a final decision in the EPO opposition proceedings, it takes quite long. And under these circumstances, it was held that a stay was not appropriate. So that was the outcome here. In view of the time, and I know that Rian has very interesting other cases to present, I suggest I'll skip this one on suspensive effect and give the floor to my colleague Rian Galden. Thank you.
Thank you very much, Peter. And we wait for Rian now. There she is.
Yes, I think I unmuted myself. Thank you, Peter. I'll take it up from here. Starting with the very first case that came up before the Court of Appeal, and unsurprisingly, this also had to do with the very first stage of proceedings before our court, which is service. And in this particular case, the registry had served a statement of claim, but without exhibits. And then the exhibits were only uploaded about a month later. The local division set the time for preliminary objections and the statement of defense as from the date of service, and refused a request by the defendants in this case to set the time period to be running from the date where the exhibits were uploaded. So the Court of Appeal was to decide on how this system of service works in terms of when the time period for filing the statement of defense starts to run. So first of all, the Court of Appeal agreed with the Court of First Instance that the time period for filing your statement of defense starts to run from the date of service, which is also clearly in the rules. But then on the question how that works out when the exhibits are not served together with the statement of claim. There, the Court of Appeal went to see how this works out in the European regulation on this, and decided that there is no need to serve exhibits together with the statement of claim, provided that statement of claim sets out sufficient details so that the defendant knows what he is accused of, and he's able to assert its rights of defense. So the statement of claim should set out with sufficient certainty that what the subject matter and the course of action in these proceedings will be. This, if you look at Rule 13.1, will normally also be the case if the claimant complies with the requirements set out in this rule. And exhibits would only be required to be served together with the statement of claim if exhibits were, for instance, be referred to in the statement of claim and are needed to understand the subject matter or course of action of these proceedings, and therefore to be considered to be to be an integral part of the statement of claim. But if this is not the case, and normally it isn't, then exhibits do not need to be served. However, if you look at Rule 13.2, that actually complements Rule 13.1 in that it prescribes that the exhibits need to be uploaded at the same time as lodging the statement of claim in the system. So the combination of those two rules ensure that all the relevant documents that the defendant needs to start working on his statement of defense should be uploaded at the time of service of the statement of claim, even if it's served without the exhibits, because the exhibits are then, once the defendant accesses the digital system of the court, also has automatic access to the exhibits. Here, of course, the exhibits were not uploaded at the same time, which was contrary to Rule 13.2, and therefore the Court of Appeal said, well, due process in those circumstances require that the time period for a statement of defense only start to run from the date that the claimant complied with its obligations under 13.1 and uploaded its exhibits in the system. The public access to the case file, I'm going to skip because I know there is another presentation following up on this one that deals with it, and maybe we can then discuss it in the Q&A session afterwards. So I move on to intervention, which came up in the case where access to the case file was requested. In this case, two law firms actually wanted to intervene in the case filed by the applicant, a member of the public who wanted to get access in the case between Ocado and AutoStore. And in this case, the Court of Appeal had to set the standard, what is required in order for a party to have a sufficient interest in the case to be able to be an intervener in such a case. And the two law firms stated as an interest that they had similar cases pending. They also wanted access to case documents. And therefore, they said, we have an interest in the criteria that the Court of Appeal will set for an application under 2621B. But the Court of Appeal denied those interventions and said, you can only intervene if you have a direct interest in the outcome of these proceedings. So not just the general indirect interest or the general interest as to the point of law that has to be decided in the case. That is not enough. You would have to have a direct interest in the actual factual case at hand. Then turning to the change of language of proceedings, already touched upon a bit by our registrar. And in this case, Both of the parties were United States-based companies, and the language of the patent was English, and also the prior art was English. Nevertheless, the claimant started this case in the German language before the Düsseldorf local division, and a request by the defendant in this case to change it into English was refused. Now, as you may know, in the agreement there is a provision which states that at the request of one of the parties, and after having heard the other parties and the panel as well, the president may change it into the language of the patent on grounds of fairness and taking into account all relevant circumstances, including the position of parties, in particular the position of the defendant. And then, of course, the question was, what is the standard to be set for this? And before going into this, one interesting issue also that has come up in these change of language cases is when you can ask for the language to be changed. If you look at Rule 323 in the Rules of Procedure, you can find that this can be done by the defendant in the statement of defense. But it has been said by the President, and that has been approved by the Court of Appeal, that you don't have to wait for this. And you can actually ask a change of language immediately. So, and also, of course, it doesn't make sense to wait for your statement of defense, because that would then already still have to be in the original language. So I would advise, if you wanted to change the language, to do this as soon as possible. Now, turning back to the criteria to be taken into consideration. So all relevant circumstances, and there the court said, well, the relevant circumstances should be primarily related to the specific case and the position of the parties. In previous cases, we also had, well, they were settled, so they didn't lead to a decision. But in those cases, for instance, it was referred to that parallel proceedings were pending in national courts, and other circumstances that did not relate specifically to the case at hand. So that's why the Court of Appeal said, well, the relevant circumstances must be related to this case where the actual request is pending and the position of the parties. So as an example, the Court of Appeal said, well, this means that you would have to look at the language that is mostly used in the technical field, and the language of the evidence that usually goes with it, including the prior art. Another factor is the nationality or domicile of the parties. And it's very often said, well, there's no interest in a change of language, excuse me, because the representative is very much able to, he masters the German language, so there's no need to change it into English. But the Court of Appeal said, well, a party itself has a direct interest that he can understand what is going on, and not only via his representative or translations, which of course is always less precise and takes time. So the nationality or the domicile of the parties is relevant. And normally speaking, so in general, the linguistic skills of a representative in that regard are not of significance. Also relevant factor is the size of the parties involved. A big company with a big legal department can more easily deal with a different language than a small company, which has less resources, for translations, or may not have people in their legal department that master different languages, or do not have subsidiaries where this can be dealt with, and so forth. Another one is the effect of the change of language on the course of proceedings. And this was in this case was of particular relevance because this related to PI proceedings. So the court said, well, normally in PI proceedings, the claimant has an interest of urgency. That's the very reason why you started preliminary injunction cases and not cases on the merit. But of course, on the other hand, if you look at the defendant position, the defendant also is bound by very strict time limits. He doesn't get to prepare the case in advance before filing something. He is confronted with a statement of claim in the PI proceedings and has to respond to this rather quickly. And therefore, dealing with that in a foreign language is, of course, also an extra handicap that will have to be taken into account. Well, then the nationality of the judges, it's very often referred to like, well, you know, we like the German language because it's German judges. Well, there the court said, well, that is not generally of any significance. The judges have been selected so that they master at least the language, of course, of the local division, but also, certainly in all circumstances, they master the English language. And you also need to take into account that it's only 1 or 2 judges in a local division that are having the nationality of that division. But there's also a 3rd judge, and there may also be a technical judge involved who doesn't have the nationality of the place where the local division is situated. So generally speaking, that's of no significance. And if a party fears that the judges don't master the English language sufficiently, they can always, of course, provide at their own cost simultaneous translation at hearings if they so wish. Then the court said, well, if the balance is equal, then the defendant's position is the one that tips the balance. Because if we go back to Article 49.5, it says that in particular the position of the defendant has to be taken into account. So there the court said, well, if you look at all those circumstances, and if the balance is then equal, you would need to look at the defendant's position. And that then tips the balance in favor of the request. And that has several reasons. And the reasons is that the applicant, first of all, already had the possibility of the choice of language, and normally speaking, also the choice of the division. But more importantly, it is the patentee who chooses the language of the patentee EPO. And doing so must anticipate legal proceedings, such as in oppositions and both national and UPC proceedings, to be conducted in that particular language. And that the language of the patent is an important factor also becomes clear from the language regime in the central division, where claims for revocation can only be filed in the language of the patent. Then turning to another important procedural point is the review system that you will find in the rules of procedure. And in this particular case, we had to deal with was where a judge rapporteur of the Court of First Instance had to deal with a preliminary objection in the main case. And the judge rapporteur said, well, I will deal with this preliminary objection together with the case on the merits, so I'm not going to decide on this up front. The defendant requested a review by the panel, which is possible under Rule 333.1, and the judge rapporteur said, no, because this decision that I will only deal with in the main case is not a management order or decision, but it's only a notice, because it says so in the rule. And therefore, you cannot have a review, because the review is only for management orders and decisions. And you cannot appeal this order, because this is not allowed. Look at Rule 21, which only talks about appeals on rejecting or allowing, and doesn't talk about appealing from a decision to deal with a preliminary objection only at a later stage. So then this party came to the Court of Appeal on the basis of Rule 220.3. And 220.3, as you may know, allows a party to come directly to the Court of Appeal and say, well, I didn't get leave to appeal from the Court of First Instance, but I think this is a relevant question to be answered, and please, Court of Appeal, take it yourself. This request was made, and they didn't only ask for appealing this particular question on whether or not they could have this 333 review, but they also immediately asked whether they could, that the Court of Appeal immediately decide on this matter by saying that it was a wrong decision in the first place, and that then the Court of Appeal would deal with the preliminary objection. Well, that was a bit too much. The standing judge then said, normally you can only come to the Court of Appeal also on a 220.3 basis after a review by the panel has been made, and the panel then subsequently gives leave for appeal or not, and in that case you can come to us, but not from a judge rapporteur decision. But in this particular case, of course, it was the judge rapporteur who had prevented this panel review to take place. So in this case, the standing judge said, well, in this exceptional circumstance, we will take the appeal, but we will only take the appeal on the question whether or not the Rule 19 decision taken by the judge rapporteur was a case management order, and therefore should have been gone to the panel for review. And the decision by the court was that indeed it was a case management order, and therefore it should have gone to the panel. And also the court said, well, we'll send it back now to the panel for this review, and then they can decide on substance, and that is not something for the Court of Appeal to do in this stage. Important, I think, to know is that an exception to this system is that the decision to reject the preliminary objection may be appealed with leave from the judge rapporteur, so there is no panel review required for this, but a review is possible as an alternative route to an immediate appeal. If a preliminary objection is allowed, this is a final decision and is directly appealable without leave from the court under 220.1. I think I've finished my time, and maybe we'll get to the other two decisions I was going to talk about at the start of the time period to lodge an appeal and claim amendments in the Q&A session if it's considered relevance. For now, thank you so much for your attention.
No, thank you very much indeed, Rian. Very, very much, you and Peter, for your excellent, wonderful presentations. And I'm sorry that we brought it to an end, but as you rightly say, we will have a question and answer session at the end after this current session is over. And actually, I would, I see there have so far not been any questions put, and I would encourage participants to do so. But if there are no questions, I think what I might do, I mean, Jochen is up next to speak, is to ask Jochen to lead a discussion with the judges and the registrar, which will be of interest to all of us, and you may well then be able to refer to the parts of the decisions which have not yet been referred to. So Jochen, I hope you'll be able to do that when we come to the question and answer session. But we should move on for the time being to our next session, which is a very important session as well, because it is views from practitioners. And there will be two speakers here as well in this session. That's Jochen, whom I do not need to introduce again, and the other speaker, Emmanuel Larret, whom I will introduce halfway through. So Jochen, please would you begin? And I understand you'll be focusing on decisions regarding provisional measures, expert testimonies, and access to written pleadings and evidence. Thank you, Jochen.
Yes, thank you, Jonathan, and thank you also for this excellent idea of having a discussion of the two panels together afterwards in the Q&A session. I think that that's an excellent idea, and we'll be happy to do that. I will try to manage the moderator's job as you suggested. Well, we will, Emmanuel and I will present to you some views from the practitioner's side, and we have decided internally to split up the time about half equal between the two of us. So I will have 20 minutes to speak, and some of the topics that you can see on the program were suggested by the organizers, and the third topic is one that I put myself on the agenda, and Rian already mentioned the access to the files, to the written pleadings. I think that is another important issue that we should try to discuss. First of all, let me start with what we have already seen from the presentation of Rian and Peter. The UPCA is the basic framework, but the music really plays in the rules of procedure. And I think the rules of procedure are a magnificent piece of work that has been put together by the small group of people, expert people who worked on this very hard for many years with different drafts and so forth. It's an extremely complex system. I mean, the UPC is an extremely complex system with lots of things to consider, and I think what we have in front of us is a very, very helpful tool, and not just some basic ground. I mean, it is really the heart of the proceedings. So as I said, Emmanuel and I have picked certain aspects which are of practical impact and importance for the dealing with the case, and also certainly in your strategic advice to a client, whether you go the route of the UPC or not. As you know, you have a choice in some cases. Sometimes you have a choice by picking different intellectual property rights, national utility models, or European patents, and so forth. What we are trying to do is or what I'm at least trying to do, sorry, Manuel, is I will raise a number of issues in the realm of discussion of some case law, and then maybe that can lead into more expanding questions. So with that, I would like to just do this. Start with decisions regarding provisional measures. As we know, one of the ambitious goals of the UPC and the UPCA is to have expeditious proceedings. So in the case of the merits, we want to have a decision within 9 to 10 months in the first instance, which is in itself already a very ambitious project. At the same time, we have a strict regime of deadlines and so forth in order to achieve that. So it is speedy, but nevertheless, there is a need in a specific given case. There may be a need for even faster decisions, which opens the route to the provisional injunctions, preliminary injunctions, and other provisional measures. As a background, we know that before the UPCA was in place, we had national courts, and there has been quite some competition between national courts on the level of preliminary injunctions, not only across the borders. We remember the old days. They are now already old days when the Dutch courts and the German courts had different views and different expectations on PIs in patent cases in particular. But also on the national level, there has been some competition between the courts in Germany, for example, between Düsseldorf and Mannheim and Munich, who was the fastest, who would offer the most preliminary injunctions, and so forth. I mean competition in the best sense, not really also like I mentioned the sports event already. So the competition here has some sporty element to it as well. But we will see how that plays out now, also in front of the UPC. So the legal basis for provisional measures is Article 62 of the UPCA, which I have put in front of you here, and that works together with rules 205 to 212 of the rules of procedure. Some of the points are highlighted here, and as you can see already, in paragraph 1, we have the court may grant injunctions. Paragraph 2, court shall have the discretion to weigh up the interests of the parties. And in paragraph 4, we will then discuss what is the satisfactory level and a sufficient degree of certainty. And we have heard from the Court of Appeal, from Peter already, a lot on this decision. So, but what we need to know is there's a discretion of the court, weighing of interest, and sufficient degree of certainty. Those are the main criteria which need to be filled now a little bit further with some flesh to the bone. Here are the rules of 205, stages of the proceedings, 209, examination of the application for provisional measures. Again, the court shall have the discretion to do certain things and to take certain actions. And we have Rule 209.2. In exercising its discretion, the court shall in particular take into account A, whether the patent has been upheld in opposition procedure, B, urgency of the action, C, is whether the applicant has requested provisional measures without hearing the defendant, and D, protective letters filed by the defendant. So this plays into the procedural side of how you deal with a motion or an application for a provisional injunction on the court side. What we need to know also is Rule 212 and 207. As we mentioned, timing is crucial in preliminary injunction cases, and sometimes it's a matter of days only. We will see that in a specific case. So Rule 212 allows an order on provisional measures without hearing the defendant. This is the so-called famous ex parte injunction. So it is explicitly allowed, which doesn't mean you will always get it. The question is, when do I get it? For example, Rule 212 says the court may order provisional measures, in particular where delay is likely to cause irreparable harm to the applicant, or whether there is a risk of evidence being destroyed. The latter case, I think, is not of such great importance here today, but where is there a likelihood of irreparable harm for the applicant? So, of course, the patentee is always interested in fast decisions, and it couldn't go fast enough for the patentee or the applicant. Injunctive relief is what that party is seeking and also expecting from the UPC. There may be specific situations or circumstances which basically call for that. Let's say one of the examples, trade fairs going on, generics in the pharma sector ready to come on the market, and so forth. On the other hand, the defendant has a risk of the ex parte decision and wants to avoid that. Rule 207 allows the defendant to file a protective letter where you can already present your arguments to the court, and the goal of that would certainly be to avoid a preliminary injunction, or at least to avoid an ex parte injunction. Whether this works or not, the first decision that came 3 weeks after the UPCA had come into force on the 22nd of June already of last year, the local division of Düsseldorf ordered an injunction and seizure without hearing the defendant, an ex parte injunction. So it was the first preliminary injunction issued by the UPC. It was at a very early stage of the UPC, and the court was basically left alone with what to do with it and how to deal with things. I must say, when you look at the decision, they have extremely done a good job in approaching detailed several issues at stake and in a very systematic way. So what happened, there was, we are talking about the local division in Düsseldorf, there was the Eurobike trade fair in Frankfurt, which is an leading international fair for biking and biking technology. So the parties were both Swiss companies, so not like you would expect, well, there is a European patentee and there may be some other party as a defendant from far away, which will appear at the trade show and will be gone after the trade show. That was not the case. We just had two Swiss companies on both sides. Motion of the patentee was for injunctive relief, a seizure, and security for cost. The panel consisted of the legal qualified judges, and they did not involve a technical qualified judge, and that is something I will get back to. So now the question, should the court or could the court issue an ex parte injunction? And in fact, they did. The defendant had filed a protective letter, so there was discretionary decision whether or not they should do that. The court anyway said, well, the defendant had the chance of being heard, so there's no need to hear him again because they did file the protective letter. The protective letter was not convincing for the court, and therefore we will have to, we have the discretion and we feel comfortable enough by all the standards that we have already heard that there should be an ex parte injunction. That leads us to the conclusion or to the question in practice, is it smart to file a protective letter, or would it be wise not to file a protective letter at all in that situation? And maybe we can discuss that also with the judges afterwards, simply because if I lose my chance by filing something which is not convincing, what happens if I don't file anything? I still have to be heard. That is one of the fundamental principles. So we will see how that plays out in the future. There was another local division, Vienna decision, completely different situation. There was sufficient time. There was a trade show coming up in the future. The parties were an applicant from Germany and a defendant from Austria. 3 months before a big trade show to be held in Milano, and there was also then the question, is there urgency? Is there an urgency requirement? Unfortunately, we did not get a view of the court on that, simply because they didn't find infringement in that case and didn't have to deal with all the other issues. There was a very specific problem in that the patent had been opted out right after a few days after the application was filed. There were 2 different people involved and so forth. Court said opt-out is not valid, but still there's no infringement, and therefore no decision. They had a full hearing in the case, so that reminds me a little bit of the situation we had back in the Netherlands with the Courtgeding, and you still have it, I'm sure, for national patents or for European patents which are not before the UPC. So shorter time frame, still a full hearing, exchange of written documents, and so forth. In the interest of time, I would skip what we heard already about the local division Munich and the Court of Appeal. Validity, there's only one question which comes up, and that is important, but I might defer that to the Q&A session as one of the first questions, namely, what do I do if I want an ex parte injunction, and what do I have to show about the validity of my patent? But I will come back to that later. One other issue that we would like to tackle, and if I'm not mistaken, I still have, well, 3 minutes left. Okay. I will try.
That's correct. That's correct.
Thank you, Jonathan. Okay, so means of evidence according to Article 53 are witnesses, but also opinions by experts. And here the term expert is used in a very broad sense. It doesn't make any distinction. Is it a party expert, a court expert? But we have a specific Article 57 which deals with court experts. And so obviously there is something the court may at any time appoint court experts in order to provide expertise for specific aspects of the case. What we had in the past in national courts was very often a court expert might have been involved in the case, appointed by the court, when there were questions of infringement or questions of the interpretation of certain terms in the patent claim construction. I know there is a legal part to it, which is totally up to the judges, and the other one, which is a matter of fact, which is then can be witnessed or where you can have an opinion by an expert. Now, this brings up the question, what about the technical judge that we have now? And the legally judges can certainly involve a technically qualified judge. Does that make the court expert obsolete in that sense, or how does that play? Or would they still be in parallel? I mentioned before the first injunction was done by the legally qualified judges only. There is one time aspect which we also can see in other decisions. It's actually in the decision that I'm going to talk about next of the court, access to the files, the involvement of technically qualified judges. So back to expert testimonies. Is there cross-examination? Yes, there is some sort of a cross-examination according to the rules. And the role of the technical judge, I mentioned that already. I would like to briefly talk about, time's up. I will take 2 minutes, Jonathan, and then I'll finish. Access to written pleadings and evidence. This decision, there's a decision of the Court of Appeal on which was rendered on the 10th of April of 24. And the interesting part of this decision, which I did not talk about, is the involvement of technical judges. And the Court of Appeal said in this question, which is a purely matter of law, we do not involve the technically qualified judges on the panel, which I personally fully agree with. And but that raises the point in in preliminary injunction cases, the involvement of technically qualified judges obviously takes some time because it needs to be appointed and adjudicated from the pool. So we can discuss that also in the Q&A session. Now, the case about access to written pleadings and evidence, I think, has a great practical impact, and it's a decision where the question came up whether a third party, which is not party to the case, may file a request to get access to the written pleadings. As we know, the decisions of the court and the orders, they are all published on the website. We heard that already, so there's no need for that. But what about the written pleadings? And there may be certainly an interest in accessing those. That is something which is totally unknown in German, as a principle, for example, in German national courts, and it takes very high hurdles. Now, there was a request, and the Court of Appeal confirmed, actually, it was granted in the first instance by the Nordic Baltic Regional Division, and that decision was confirmed by the Court of Appeal. So saying that the general principle laid down in the UPCA is that the register is public and the proceedings are open to the public, unless the balance of interest involved is such that they are to be kept confidential. The question arose whether proceedings also includes the written procedure, and here the Court of Appeal relied on Article 45 of the UPCA. If you see, it says the proceedings shall be open to the public, UPCA public proceedings, and we have Article 52, proceedings shall consist of written, interim, and oral procedure. That is the basis for the conclusion of the court to come to that obviously, Article 45 opens up the written proceedings, the written materials also to the public. I think that may certainly be questioned, on one of the reasons being, if we look at the other languages, the German and the French version of the UPCA, the heading is different. And the heading of Article 45 in Germany is Öffentlichkeit der Verhandlungen. So it means publicity of the hearings. And the same is in Article 45 French, débat public. This is the debates in front of the court, but not the proceedings. There is a difference there. So this may have been something that has been overlooked when setting up the UPCA, but I think it is an important point simply because with the ruling of the COA, the Court of Appeal, I think it looks like there's always, the public interest always comes first, and only under very, very limited circumstances can that access be denied. And I personally don't agree with that. I think there must be more to that, and there should be more of reasoning in the reasoned request. Maybe I'm misunderstanding the decision, but I think that is something that needs to be discussed and should maybe clarified next time they get a chance to do that. There has been some case law of the Central Division of Munich, which took a little bit of a more, I don't want to call it balanced view, because there is certainly a balanced decision in the COA, but it said it requires a concrete, verifiable, legitimate reason for making available written pleadings. And the general interest of the public should not be the same as this concrete, verifiable, legitimate reason. So with that, my time's already up. Thank you very much. And I pass on to Emmanuel.
Thank you very much, Jochen, and we will hear from you again shortly, as we discussed a minute ago. So our final new speaker is Emmanuel Larère, who is a French lawyer who focuses on non-contentious and contentious patent and trademark matters. He has over 30 years' experience in these fields. His patent litigation practice covers life science, including biotech, technologies, and traditional industrial sectors. He's also a renowned specialist in trademark law in some of the leading brands in luxury goods, sports apparel, and jeanswear. Emmanuel, please, over to you. You will be dealing with revocation actions.
Yes, thank you very much, Jonathan, and thank you all for inviting me today. I'm really pleased to be in a position to have the possibility to share my experience after 1 year of the UPC and focusing on revocation actions because I was involved in one of the very first revocation actions, and because revocation actions are extremely important. They were introduced in the preamble of the UPCA. The 5th paragraph of the preamble says that one goal of the UPC is to improve the defense against unfounded claims and patents which should be revoked. So I will try to give you a few information and few thoughts regarding the specificities of revocation actions in front of the UPC, the legal basis, a few statistics, a key question, which is the same parties issue and the consequences for the competence of the central division or the local divisions. A few words about the bifurcation, which is an option in the UPC. And finally, if I have time, I would like to share some very short reflections after 1 year of practice. So let's start immediately with the legal basis. As I'm sure you know, there are 2 ways in which revocation actions can be judged by the UPC. In other words, we have 2 venues for these revocation actions. The central division for main actions, and this is combination of Article 32(1)(d) and 33(4) of the UPCA, so main action, central division, but you can also file a revocation action as a counterclaim, and this is based on Article 33(3) of the UPCA. So what are the figures regarding these revocation actions and the distinction between main actions and counterclaims? So, and I saw that on the website of the UPC at the end of May 24. So out of 373 cases, we have currently 39 main revocation actions before the central division, 35 in Paris and 4 in Munich. That means that a little more than 10% of all actions pending before the UPC are currently revocation actions, main revocation actions. Now, if you look at the counterclaim, so there are several figures because we saw previously in the numbers that they are 134 infringement actions which are pending, but depending on the way you count the counterclaim for invalidity, you can find 165 counterclaim for revocation, which is a little bit strange, but the explanation is that until recently, each defendant in an infringement case needed to file an individual counterclaim, and that was counted for one. But if we try to focus really on the independent action, I think we can come to the figure of 63 individual infringement action with counterclaim for revocation actions before the various local divisions. From a French perspective, this number could seem a little bit low because in our practice, in most of the infringement cases, you have a defense regarding the validity of the patent. So it seems that at the UPC, it's only on half of the infringement cases that, as a defense, a counterclaim for revocation is lodged. So we have seen that the actions can be brought either before the central division or before the local divisions, but there are situations in which only one of the two venues can hear a revocation action, and it is when we have the same patent, obviously, but also the same parties. And the same parties issue has been already addressed by two divisions, but let me first start by the legal, I mean, the article which has to be implemented in this situation. So a revocation as a main action has to be filed in the central division unless, and this is Article 33(4) of the UPCA, unless such an action is already pending before the same parties before a local division, or an infringement action based on the same patent is pending between the same parties before the local division. And we have two cases in which local and central division had to explore this concept of same parties. We probably thought when we read the text at the very beginning that it was crystal clear, but the reality of the creativity of the parties proved that this question was discussed. So let me first start with the Edwards versus Merrill case. And I would like first to let you know that I was and I am in this case because I am representing one of the Merrill entities. So in this case, Edwards, the American patentee, sued two entities of Merrill, Merrill Germany and Merrill India, for infringement of one of its patents before the Munich local division on the very first day of the UPC, which was the 1st of June 2023. On the 4th of August, so a few weeks after that, another entity of the Merrill Group, Merrill Italy, which I was representing, filed a main revocation action in front of the Paris Central Division against the same patent. And so Edwards, through a preliminary objection in Paris, argued that this second action was filed by the same party that the two already sued in Munich, and that the Paris Central Division should refer the whole case to the Munich local division. We pleaded this question at the end of October, and at the beginning of November, the judge rapporteur refused to follow Edwards and ruled that different entities, even if belonging to the same group, were different parties. He also said that this independent main revocation action was not an abuse of the system because of the numerous procedural tools in the hands of the judges, in the hands of the divisions, to avoid inconsistencies between decisions. And I will show you later that indeed a solution was found to avoid inconsistencies in this situation. No appeal was filed by Edwards against this order, which means that this order is now final. The fact that it was a subsidiary, another subsidiary from Merrill that was involved was the key point used by Edwards. But if you think that a distributor or a licensee or even another competitor could have filed also an independent revocation action against the same patent, despite the fact that there was already an infringement action based on this patent, it seems to me that the situation was pretty clear. The other case where this question was addressed is the Amgen versus Sanofi case. Even if in this case the factual situation was, in my view, simpler. As you might remember, on the 1st of June, Sanofi had filed a main revocation action against Amgen before the Munich Central Division. And a few minutes after, Amgen had filed an infringement action based on the same patent against Sanofi, but this time before the Munich local division. So before the Munich Central Division, the defendant filed a preliminary objection and argued that the Munich Central Division was not competent to hear the revocation because of the counterclaim which was lodged before the Munich local division. Here, the question of the parties was settled very quickly because indeed, in both cases, the parties were exactly the same, except that there was in the infringement action a third party, Regeneron. But so the court recognized that the parties were identical. But the key question here was not exactly the identity of the parties, but the timing between the procedure. And the Munich Central Division retained its competence because the main revocation was filed before the infringement action. So to sum up on this question of the two venues, it seems to me that when the parties are really identical with no discussion, and if the infringement action starts before a main revocation action, then Article 33.4 could be enforced. Otherwise, there could be simultaneously, and this is very interesting from a practical standpoint, there could be simultaneously a main action and a counterclaim for revocation regarding the same patent. So now what about the bifurcation? As I'm sure you know, bifurcation has its origins in the German practice, where infringement on one side and validity on the other are not examined together and not by the same court. Infringement litigation are held before dedicated patent court. In fact, it's civil chambers of specialized chambers, sorry, of the civil court, whereas the validity of the patent is heard by the federal patent court. This is probably, and as Germany was absolutely key in the building of the UPC, this is the reason why the founding fathers of the UPC decided that bifurcation should be proposed to the parties as an option. And indeed, Article 33(3)(a) and B of UPC-A say that when there is a counterclaim for revocation, the local division shall either A, proceed with both actions and then appoint a technical judge, or B, refer the counterclaim for decision to the central division and then either suspend the infringement action or proceed with this action. So now that we see how the system was implemented, which was clearly for my view, for the German practitioners, what is the reality of the UPC since day one? So far, and even if I don't have comprehensive figures, it seems that local divisions, including local divisions in Germany, clearly avoided bifurcations. And the reasons for that can be found and can be summarized with 2 or 3 very clear sentences used by the judges to explain why, in their view, there should be no bifurcation. And it started by a decision from the Düsseldorf local division in December 1923, with this reasoning. And I quote, "Joint hearing of the infringement action and the counterclaims seems to be appropriate, in particular for reasons of efficiency." So first reasons, efficiency. It is also preferable because it allows both issues, validity and infringement, to be decided on the basis of a uniform interpretation of the same panel, of the same patent, by the same panel composed by the same judges. And I like the way the word same is repeated 3 times. And we find pretty much the same wording in a decision from the Hague local division in February, where the court refused the bifurcation. I quote, "because it allows both issues, validity and infringement, to be decided on the basis of a uniform interpretation of the patent by the same panel composed of the same judges." It seems to me that even if unless I'm mistaken, the Court of Appeal did not rule on this issue yet, but it seems to me that in several decisions of the Court of Appeals, you can find another basis for the same conclusion, and it is regarding the and that was discussed earlier regarding the principles for the interpretation of the patent claim. And it was decided, for instance, in the Vision Group versus Hancho Technology in May by the Court of Appeal, and I quote this short sentence, but which is extremely clear. These principles for the interpretation of a patent claim apply equally to the assessment of the infringement and the validity of a European patent. This is not a surprise, of course, for a French patent litigator, because this is how our system was working and is working, and this is the same in a lot of continental European countries. But it is interesting to see that the option of the bifurcation so far was not used by the local divisions. So here it was the question of referring the validity to the central division. There is another case where the question of the referral was this time the infringement, which was pending obviously before a local division, to the central division. And the Mannheim local division also refused in this circumstance to refer the infringement to the central division. The main revocation action was filed first between party 1 against the patentee. Then an infringement action was started before the Mannheim local division between the patentee and parties 1, but also parties 2 and parties 3. And this is why the local division refused to refer the infringement action to the Paris Central Division, because 2 parties out of 3 were different, and the 2 proceedings were at very different stages. On the contrary, we have very rare situation for referral to the Central Division. The Sanofi Amgen case is, in my view, exceptional, because it was an unanimous request from all parties to refer the invalidity to the Central Division, which was also in Munich, and this was accepted by the court. In the Edwards versus Merrill, the Munich local division decided to refer the case to the Paris Central Division, saying 2 things. First, and I quote, the Munich local division's panel agrees with the party's point of view that in general, it is advantageous to hear infringement and validity together. So they repeat the principle. But here in this situation, joint hearing of the Paris Central Division and of the Munich local division counterclaim action seem a way to avoid inconsistent decision regarding the same patent. And what is interesting is that the case was referred to the Paris Central Division, and we had the hearing on the 7th of June, but it was a single hearing, but with 2 independent cases. So the counterclaim was referred to the same panel, but the cases were not joined. They were not merged, if you wish. They were heard together. So to sum up on bifurcation, it seems to me that in classical situation where there is an infringement action pending before a local division and a counterclaim for invalidity is filed, then normally there should not be bifurcation, but you have exceptions, especially when a main revocation action is already pending and when the goal of all the parties, if the timing are pretty much aligned, is to avoid inconsistencies of decision. And in the last,
we should, Emmanuel, sorry to interrupt you. We should end now because we've got about 10-12 minutes for questions, if you don't mind.
So I just wanted to say how happy I am after 1 year of practice, and just to confirm what Alexander said regarding not only the efficiency of the staff and of the IT, but of the IT people, but really their kindness. And personally, I faced some difficulties from time to time, but every time it was solved very quickly, very smoothly, and it's great. And I'm happy to see that the promises of the UPC have been kept, because in my case, I filed the statement of revocation on the 4th of August, and we pleaded on the 7th of June. So less than 1 year. It's really extraordinary for a patent practitioner. So I'm definitely a happy avocat at the UPC today. Thank you very much.
No, thank you very much, Emmanuel, for your excellent, clear presentation. Thank you. We go into questions and answers, and there is actually a question from participants with which I'd like to begin. I assume it's for the judges, but I leave it to the whole panel to decide who wants to answer it. From Erani Zuvani, who says, since the UPC did not have precedence of its own so far, what approach did it hold in adopting or interpreting legal principles through case law of other courts, both domestic and EU? So I don't know who wants to answer that question. Somebody volunteer, please.
Well, I can say something about it. As far as EU law, of course, if there are decisions of the CJEU, there's no debate that the UPC must and shall follow the precedents. As respect to national law, it's of course true that that there are various precedents in various national jurisdictions. And of course, we take that into account in the sense that we're not starting from scratch, but built upon the wisdom in the case law of the national courts. But to the extent that that case law is not harmonized, and as you know, in some areas there is no harmonization yet, we have the task to find a harmonized approach. And in that sense, it's building upon the national case law, but also adding something to it.
Thank you.
I hope that answered the question.
Yes, thank you. Jochen, I've seen your hand up, but Rian, you were about to speak before, so go on. Rian first speak, and then we'll come to Jochen.
Well, from a procedural point of view, I can confirm what Peter says. So, for instance, with intervention, we had a look at case law by the Court of Justice, and on several occasions we referred to it as well, like with the service of the statement of claim. We had a look at the European case law on this. But for instance, on the access to statements and evidence, of course, there was no sort of a common background on this. If you look at the national systems, they basically range from not making anything available at all, unless under very, very rare circumstances and to a very limited extent, like in the Netherlands, and making everything available at any point in time, like in Sweden. You know, without there being any further background basically for us, we have to come up with rules that we think are meant by the legislator. So you go and have a look at the agreement and the rules, how they have been drafted, and also try to find a balanced approach, taking into account all the interests of those that have an interest involved. And so I think we have come to a decision on this matter. Well, if I may say myself, in a rather balanced way. And I do appreciate that it's new to people who are not used to statements and evidence being made available at some point, as well as those that may are used to more transparency at any stage of the proceedings. But in the end, I think some decision has to be made, and somewhere in the middle ground, I think we found a solution, that also gives quite straight guidelines that can easily be applied in these cases. Same with the languages. You just look at the interests involved and then come to a balanced approach. So I think that's the way we look at it.
Thank you, thank you. Our two practitioners want to speak as well. Jochen, you first.
Thank you very much. I'll be brief on that. Well, first of all, I fully agree with what Peter and Rian have said, and I think the general approach would also be to find some kind of, well, it's a term, best practices that we can see in different national regimes. And when the project was set up, I think that was one of the goals, to come to a reasonable, balanced system where we could use the advantages of the national system and maybe avoid problems that national systems undoubtedly had and still have. We may have to distinguish between procedural issues and matters of substantive law. Substantive law, yes, we can build on what there is, but especially the doctrine of equivalence, for example, that'll be very interesting to see how that evolves. And that is one of the advantages and also challenges at the same time, that we have mixed panels. We don't have a German panel, we don't have a French panel or a Dutch panel on the court. We have panels with views from different countries, and they should all be able to bring in their ideas, and I'm sure the court, the UPC, will develop its own case law on this, which may deviate from national laws and should probably also. And at the same time, I would like to Rian, what you just said about the access to the files and so forth, absolutely right. A decision has to be made. Nevertheless, I think the court should also not be shy to revisit certain issues in the next decision, and not just because it has been said once, shouldn't be there once and forever. I think especially in the beginning, there is lots of room, and everybody will understand if the court deviates from earlier decisions or fine-tunes it or whatever you say. So I think that should be an opportunity and a chance to be seized. Thank you.
Fine, thank you, Emmanuel. And I suspect we will then have to conclude since we have 4 minutes left. Emmanuel, please.
Yeah, really a few words to say that it's and the question was great, because what for me is so exciting about UPC is that it is a true international court, and it would be a true pan-European court. And it would be a huge mistake to think that because you are in a German local division or in a French local division or in a Dutch local division, you are in front of national subdivisions of the UPC. This is absolutely not the case. And so everyone, and this is why it is so refreshing, is bringing, and when I say everyone, it's the lawyers, but of course the judges and the interaction between the two. Everyone is bringing its own judicial culture and decisions and precedents, and you should mix everything to try to find a new path, a new way. And it is true that, I mean, the learning curve was steep, sorry. And for instance, in my case, I had one question, a procedural issue, which was pending before the standing judge of the Court of Appeal, because the first instance judge refused the leave to appeal. This is something totally unknown from a French perspective, because the right to appeal is an absolutely right, and a right absolute. So you never discuss the opportunity. So we were in defense in this situation, but it was very exciting, challenging, and refreshing to use and to manage with other practice to finally build an independent reasoning regarding an issue which in our day-to-day practice was totally new. So it's great.
Very good. Very good. Thank you very much, Emmanuel. We have just a couple of minutes left, so I think we should leave it there. And I would really like to thank our judges, the registrar, and our practitioners for their excellent presentations. If you look in the chat, you will see that the participants are expressing their great appreciation for your presentations. And so on their behalf, I collectively, I also say thank you very much indeed for your time. I thank our participants for their time. And on that point, I draw the webinar to a close. Thank you to everybody and goodbye to everybody as well. Bye-bye.
Bye-bye. Thank you very much.